to talk a bit about the industries that might be affected by the international regime on access and benefit sharing, which is currently under negotiation, and then to focus on the international regime and how the private sector can contribute to it. I think the first thing to say is that the international regime on access and benefit sharing is one element of the CBD's activities. The CBD, I guess, has as its overarching goal to achieve a significant reduction in the rate of loss of biodiversity by 2010. That was a goal set in 2002. Realistically, the things that particularly affect loss of biodiversity are not the things that will be the subject of the international regime. It tends, I think, realistically, it's things like major extractive industries and so on, urbanisation, things like that. Nevertheless, the international regime can play its part. But CBD does exist in sort of quite a complex institutional framework. The international regime will not be the only international agreement which addresses ABS. We already have the International Treaty on Plant Genetic Resources, which is up and functioning, and which has all the characteristics of an ABS agreement. There are others as well. Some of them are multilateral, some of them are bilateral, for example, scientific cooperation agreements between governments, and some of them are even non-state agreements. So it's quite a complex environment. In addition, the discussions on the international regime have to deal with some very difficult issues, which I'll touch on again in a minute, such as traditional knowledge and the patent disclosure debate. And I think it would be fair to say that the expertise on these issues in the institutions actually lies outside CBD. And in the past, the practice in CBD has been to ask for technical advice from the appropriate organisations, be it WIPO or elsewhere, on these issues. The international regime is supposed to be presented to the Conference of the Parties in 2010. They've just finished the last negotiating session, which I'm told concluded, as the previous one did, in a document with literally thousands of square brackets in it, and I don't have to tell this room what that means. Suffice to say, 2010 looks like a challenge at this stage. I wanted to move on now to talk briefly about two of these complex issues, TK and disclosure, really to illustrate how it's difficult to move forward to the conclusion of the regime unless you have a sense of the fundamentals of what you're dealing with and how these different things interact. First of all, scope of the international regime. It's concerned with genetic resources, but it must also support Article 8J of the Convention, which deals with traditional knowledge, and contains a number of obligations on the parties to the Convention. So, our interpretation is that the coverage is, in effect, traditional knowledge associated with genetic resources. The objective is limited to Article 8J, and the reason I say that is because I don't see anyone suggesting that the negotiations on the international regime are going to lead to the establishment of a system of recognition for traditional knowledge or anything of that sort. Indeed, the underlying questions about traditional knowledge have not been particularly advanced by the regime, and those debates continue elsewhere. So questions about how relevant existing IP tools are to the protection of traditional knowledge, to what extent we can use improved databasing and management of traditional knowledge in order, without offending cultural sensitivities, but in a way which makes traditional knowledge more available, both for purposes, for example, of patent examination, will have to be continued elsewhere. One issue that I think has been thought about a bit in the international regime is the interface between national and customary law. So I put our view on the table, which is that this ultimately has to be a question for individual countries. The cultures of the different indigenous groups in different countries differ. Their relationship with their national governments differ. To be frank, as essentially people are operating in the global trading system, we need certain things that in the sense of legal certainty and so on, but we find it very difficult that you could imagine that the international regime should ever be able to dictate down to the detailed level of local communities how it will function because of the diversity that's out there. So we expect the IR to provide some legal certainty, but also to be quite clear in saying which things are there for national regimes or national regimes to resolve in a transparent manner. The second complex issue is disclosure obligations in the patent system. Within the international regime, disclosure is normally looked at as part of the debate about compliance, which is, if you like, is one of the sort of chapter headings in the regime, and it's one of a really very lengthy list of ideas that are in circulation. We see substantial problems with disclosure, starting with definitions. To put it in a very practical level, unless potential applicants for patents can be absolutely confident of when they have to disclose, there is a significant deterrent to them, and in very many cases, in a situation where this is not core business for them, they are simply not going to pursue the opportunity. It isn't worth the risk. If you can't be certain about your legal title, you don't take the risk. That's the message we've had over and over again from our members. Of course, the threat is increased if failure to disclose, however defined, is subject to penalties, whether those are inside or outside the patent system. And we have expressed over time these concerns to people, and we have illustrated through case studies and so on the subtleties that are involved, and I hope you will understand this as a result of the presentations this morning, the subtleties that are involved in making the relationship between a natural material and a final pharmaceutical and establishing what the contributions are. Very complex. And as I say, we haven't had satisfactory answers from any of the governments we've talked to. There is a second question about disclosure, which is really about objectives. Disclosure is intended to achieve an objective, but I have to say, having watched the debate for some time, disclosure is a bit like it's the sort of the character in the drama who is always there, but always seems to change personality slightly depending on what you want him to do. So people have said, well, it's about preventing bad patents. They've said it's about addressing non-transparency in the use of genetic resources, or it's about countering outright misappropriation. Our view is that it doesn't deliver particularly satisfactorily on any of those things, but it remains a sort of something that is there in the debate. And indeed, in some of these areas, there are now, potentially more useful ideas in circulation. Our major concern is that we see very little to be gained from disclosure, but we do see that badly handled it will be a major deterrent, and what we're trying to describe today is an area of research which needs to be cultivated rather than regulated out of existence. Turning to the mandate for the regime, which you have here. I talked a little bit about 8J, so I'll focus on the other two elements.